Thank you, everybody, for coming in the middle of a rainstorm. I'd like to welcome all of you to this joint panel between the American Enterprise Institute, the Pacific Legal Foundation, and the National Review Institute. I hope this is the first of many collaborations between our three great institutions. And I'm going to turn it over to Elizabeth Slattery, who's going to be moderating the panel and will introduce the speakers, of whom I am one, so she better not screw that one up. Elizabeth, take it away.
Thank you. Well, thank you all for joining us this evening, and I want to thank our partners, National Review Institute and American Enterprise, and I'm here on behalf of Pacific Legal Foundation. We're excited to talk about the Supreme Court's term, and what a term it was. The justices decided pressing cases that were closely watched by Americans and many people all across the world. I'm talking, of course, about cases involving the Hague Convention, arbitration and airport cargo loaders, and Senator Ted Cruz's ability to repay a personal loan from his campaign. That's what you're all here for, right? But of course, we're going to talk about the biggest of the big cases: Dobbs, Bruen, West Virginia versus EPA, and so on. So let's get into it. We have a distinguished panel here today, and they hardly need an introduction. First up is John Yoo, who we just heard from. He is the Emanuel Heller Professor of Law at the University of California, Berkeley. He's a non-resident fellow here at AEI, a visiting fellow at the Hoover Institute, and one of the personalities behind the popular podcast Law Talk with Epstein, Senek, and you. Next, we have Jess Braven, who writes for the Wall Street Journal, where he offers incisive, rapid coverage of the Supreme Court, from the most important rulings to the mundane. His article from a few years ago about how the most junior justice is in charge of the cafeteria committee is, to this day, one of my favorites, and it included gems like, "It isn't a job that justices relish." And then finally is Ramesh.
Get it?
Ramesh Ponnuru is editor of National Review, a fellow here at AEI, a columnist for Bloomberg Opinion, and he and his wife, April, were once recognized as a Politico power couple.
All the power's hers.
Truly greatness in this room. Okay, so with that, let's dig in. We're going to not bury the lead. We're going to kick things off with the biggest case of the term, of the decade, perhaps of the last 50 years or so, and that's Dobbs, in which the court upheld Mississippi's limit on abortion after 15 weeks. So, Ramesh, tell us about that case.
All right. The tricky thing about discussing Dobbs in a forum like this is not so much that everybody has a strong opinion about it, but that there's not much that's left to be said about it. There's been acres and acres of commentary, some of which I produced myself. But I'm going to just talk about two related aspects of the case that I think are underappreciated or misunderstood a little bit. And that has to do with the breadth of the ruling and the treatment of precedents in the majority opinion and some of the concurrences and the dissenting opinion. First, on the breadth, without trying to kind of stack the deck and suggest that this is the majority opinion is kind of moderate overall, I do think you can see its treatment of the breadth of the decision, the question of sort of how widely to sweep, as being kind of in between in between Roberts. I did a mental slip and made him Kennedy for a minute. Probably not totally coincidentally. Between Roberts on the one hand, Chief Justice Roberts on the one hand, and Justice Thomas on the other. So Chief Justice Roberts argues you don't need to make a decision about Roe or Casey in order to decide this case. You can just say, we're going to uphold this law. There's some abortion rights. We're not going to, or at least we're not declaring now that there's no abortion right. But whatever that abortion right is, it doesn't cover abortions after 15 weeks. Justice Thomas, of course, suggests that, well, as long as you're reconsidering this, maybe you should also reconsider all of these other cases from Griswold to Obergefell. And Justice Alito's majority opinion doesn't go with either of those routes. I think Justice Alito has a persuasive response to Chief Justice Roberts' argument. But I think in some ways his task is made easier in responding to both types of objections. Justice Thomas doesn't really couch his argument as a criticism of the majority, but one could imagine, and one has seen off the court people make this criticism, they should have gone further. They should have gotten rid of all these other substantive due process decisions. And part of Alito's answer is, look, the parties in this case are asking us to make a decision about Roe and Casey. None of them is asking us to try to find some sort of Chief Justice Roberts-like split the difference position. And none of them is asking us to reconsider the entirety of all of this substantive due process jurisprudence. Nobody's asking us to reconsider Griswold or Obergefell. And he goes through the amicus briefs, which, there's not one really for the Chief Justice's position. But I think beyond the question of sort of what they were asked to do by the parties in the case, I think there's just a logical argument that, you do actually have to, sweep a little more broadly than Roberts wanted to do. But you don't have to go as far as Thomas was suggesting one might do. And here we come to the other point that I wanted to make, which is about the exact distinction that Alito's majority opinion makes between Roe and Casey on the one hand and Obergefell and Griswold and other cases, Lawrence v. Texas, I should also mention, on the other. And it's not a distinction that he comes up with himself, which a lot of the critics, I think, have missed. He actually goes back to Roe v. Wade and points out that Justice Blackmun himself draws this distinction. He argues you can't infer a right to abortion from the right to contraception that we've previously recognized because it involves what Blackmun calls potential life, and what Mississippi was calling, unborn human life. And that's the key distinction that he's making. It's not so. So if you go back to the way he's thinking about this, if the Supreme Court is going to protect a right under the 14th Amendment, it either has to be an enumerated right, it has to be deeply rooted in the nation's history or tradition, or it has to be inextricable from a right that is either enumerated or deeply rooted in our tradition. And his point is, because of this distinction, which the jurisprudence always acknowledged, you can't do that in this case. It's not a deeply rooted tradition, and it's not inextricable from something broader. So if you think back to Griswold, what's Griswold saying? Griswold's saying there's a right to marital privacy. If you don't have a right to contraception, you're inevitably going to intrude on this right to marital privacy, which is deeply rooted in American tradition. Blackmun recognizes that argument's just not going to work in the case of abortion, and then Alito sort of applies that. What he says, that obviously differs from Roe, is that Roe's basic argument that on the one hand you've got this right to an abortion, and on the other hand you have the state interest in potential life, and we're going to split the difference and say that until viability one of these things rules, and after viability one of these the other can rule. None of this has any constitutional basis, but I think that the debt of the decision to what at the time was not really thought of as an important concession in Roe has gone unacknowledged.
So at PLF, we litigate a lot of cases involving economic liberty, and there isn't a right to earn a living expressly stated in the Constitution. So should litigators like us we at PLF, should we be concerned about other unenumerated rights?
Well, I think that there's a couple reasons for being skeptical that sort of the maximalist interpretation of the decision is going to be borne out. One, you've got to have a case in controversy. So this is the thing that I keep wondering about with respect to Griswold or Obergefell, for example, where is the case that's going to wind its way up the courts that is going to squarely present the issue to the court, assuming the court even wanted to take it on, of do we affirm or overturn these decisions. And then the analysis of the force of the precedents is different as well. On the one hand, I mean, first you've got this question of whether some of these other rights can be derived from a deeply rooted right or an enumerated right. But then you've also got the analysis of reliance interest, the analysis of workability, and those things may just very well be different in different cases.
Jess, John, any thoughts you want to share on Dobbs?
I had one question. Maybe this is a good one for John because he works so closely with Justice Thomas. He was the senior justice in the majority. This was the most important case for conservatives, for liberals, for anyone for half a century. Why not assign it himself? Why assign it to someone more junior, Justice Alito?
Well, thanks, Jess, for trying to get me to break attorney-client privilege, but I won't. But I think you can explain it just by looking how the votes line up and what they said in their opinions. As Jess says, the senior-most justice in the majority assigns the opinion. You would think in a case of this magnitude, Justice Thomas would have taken it for himself. Although theoretically, Chief Justice Roberts might have been able to assign it in the beginning because he did, in the end, vote to uphold the law here, but on totally different grounds. So you might ask, why didn't Roberts assign it to himself and try to work out a compromise? That's an interesting. I expect the journalists should be tracking that down. Why did that not happen? Right?
So just passing the hot potato back and forth.
But in terms of the Thomas, and this goes to a point Ranesh pointed out, is Justice Thomas, it doesn't seem to me, fully agrees with the analysis in Justice Alito's opinion. Because there's an important part where Justice Alito and Justice Kavanaugh writes a separate concurrence on this point where they say we are not going to look at Obergefell. We're not going to look at the contraceptive cases. We're stopping our examination of precedent at Roe. Thomas doesn't believe in that, because Thomas does not believe in precedent, as he said so many times. And so his opinion basically says, why aren't we looking at all the other cases too? So if he had that view, he really couldn't write the majority opinion. And the other thing on the substance is he says, I think it's really the Privileges and Immunities Clause that is the source of all unenumerated rights, not the Due Process Clause. And so if he has that view, he can't write the sort of consensus opinion that Alito did. And I think you follow the court, all of us have followed the court for a long time. I can't say you would say the majority opinion had any surprises in it in terms of the way the
Since it was leaked.
Yeah, that's true. That's
Almost
true.
word for word.
He didn't change any of it when it came out. Right? But even the leak wasn't surprising in the sense that this is really the opinion is really the summary of conservative criticisms and some liberal criticisms of Roe that have been going on for almost 50 years. And so there was nothing new or dramatic like that the way Thomas's view would have shaken things up. So I think that's why Thomas doesn't write it.
Well, and speaking of privileges or immunities, I think other than Justice Thomas, Justice Gorsuch is the only current member of the court that is particularly interested in that part of the 14th Amendment. So should we move on to guns?
Yeah, we've done all the analysis of Dobbs.
Yeah.
I'm sure people will have questions.
What is there to say?
What is there to say? Yeah, so.
Well, just to finish up, just to update people who haven't followed it today, Justice Thomas's concurrence was cited in a bill the House passed today, mainly along party lines, but 8 Republicans joined it as well, rejecting his concurrence and establishing a federal right to contraceptive access. And that bill was surprising to me. It's called the Access to Contraception Act or something like that. But it was interesting the way that it did cite precedents from Griswold forward, Griswold, Eisenstadt, which extended that right to unmarried people, and the Thomas concurrence, and was a direct response in a way that we really haven't seen from the Congress, in recent years. Unlikely it will get a lot of traction in the Senate, but it is an interesting expression of one branch responding very directly to what another branch
There's
said.
something on that, Justice, which is what the justices want. If you take seriously their view of politics, they want the Congress and the states to re-engage on abortion, contraceptives and make the decisions, not them. So you might say they're, now whether Congress can override, abortion, Dobbs is a different question, but they should be glad to see, right, this kind of political response.
The bill does go further than Griswold or other Supreme Court decisions involving contraception in that, for example, it has explicit language superseding the Religious Freedom Restoration Act, which I think that helps explain why 195 House Republicans who presumably don't all or even mostly object to Griswold or a general right to contraception rejected that bill.
Right, and that was a response really to the Burwell versus Hobby Lobby case in 2014, when Justice Alito, again writing for the majority, said that the Religious Freedom Restoration Act entitled private employers to exemptions from the Affordable Care Act contraceptive provisions. So that was an interesting form of re-engagement, and I think that does explain it. And it also gets into one of the follow-up questions to Dobbs, and then I'll talk about guns, I promise, which is, what if state legislatures disagree or individual employers disagree with the FDA definition of a contraceptive? And do they redefine it, or do they legislatively declare it to be an abortion-inducing drug or device? And is there a conflict between the federal, the FDA Act and state law and the constitutional protection, if it remains, for contraception? So that is one of the trailing questions I think that we haven't seen, and what at least this bill brings it up. We don't, obviously it doesn't resolve it. Well, let me talk about the less interesting case, which is guns. In a normal year, I think we would view that as the most important case. It certainly is an extraordinarily important case. In 2008, the Supreme Court found that the Second Amendment included in the Heller decision an individual right to armed self-defense within the home, and in 2010 extended that through the states, through the 14th Amendment in the McDonald case. But after that, the Supreme Court pretty much went dark, and some of the justices, Justice Thomas particularly, but occasionally Justice Alito or Justice Gorsuch, felt that the court was ignoring the expected elaboration of the Second Amendment right, that it was turning down many, many appeals from lower courts that had upheld gun and weapons regulations using a two-part test. One, does this regulation implicate the Second Amendment? Well, yeah, if it's dealing with guns. And two, is the regulation justified by, correct me, important government interest or compelling government interest? What's called intermediate scrutiny. Was the regulation justified as a burden on the right in light of the public interest? And that was the way, I think universally, that federal appeals courts and probably most state courts were following the two big gun cases from 2008 and 2010. And some members of the court were very unhappy that basically 95% of gun regulations are being upheld on those grounds. And gun regulations, incidentally, are in a minority of jurisdictions in the country, but they are in some populous and well-known jurisdictions. But with the change in membership of the court, you had new justices who were much more interested in engaging in Second Amendment analysis. We know that certainly. I mean, when Justice Gorsuch was nominated, the NRA spent $1 million on ads promoting him. They certainly thought he would be sympathetic to their ideas. And we know that Justice Kavanaugh and Justice Barrett also were, because in dissent as lower court judges, they articulated a different test for evaluating gun regulations. And their test was essentially, I guess you could call it the history and tradition test. Does the regulation, is it consistent with regulations that were accepted during the founding era or in 1868 when the 14th Amendment was adopted? And under their test, many people expected that some regulations would pass while they might not under the two-part approach that appellate courts took. Well, what happened in this Bruen case, Bruen versus, or rather New York State Rifle and Pistol Association versus Bruen case, was that the Supreme Court adopted the dissenting position of Justice Kavanaugh and Justice Barrett back when they were appellate court judges, and made that the doctrine going forward for evaluating gun regulations. That's what happened doctrinally. History and tradition is now the test. The law at issue was a law that dated from 1912 from New York, that said that to get a concealed weapons permit, an applicant had to demonstrate reasonable or rather a appropriate cause, proper cause, I think it said, and have good moral character. And it didn't define what those were, although over the intervening century, New York state courts had elaborated that law to explain what specifically it meant. But it did give discretion to the local sheriff or police chief in deciding whether to issue a concealed weapons permit. Two people in Rensselaer County sought permits from the local authorities. They got limited permits that allowed them to carry weapons under some circumstances, but not any time they wanted outside the home, and they felt that was an infringement on their rights, and that was what this case was about. Are they entitled, as a matter of constitutional right, to a presumption that they can carry a concealed weapon in public without having to justify a reason for it? And New York wanted a reason such as not just you're afraid of being mugged, like many New Yorkers are, but rather you have a specific reason to think you are being stalked or what have you. They wanted you to show some special reason why you were different from the general public. And the Supreme Court said in the 6-3 decision written by Justice Thomas that New York had it wrong. And what's interesting is, again, the opinions are all about history. The majority opinion explains why, from the majority's view, the regulations in effect at the founding or at the Second Amendment's ratification, 1791, and also they said identically when the 14th Amendment was ratified in 1868, that the understanding was that Americans had this pre-existing right to armed self-defense, which was codified and reasserted, and that there were not regulations present at the time that led them to believe that this type of law from New York State was permissible. The dissenters, and this was, I guess, Justice Breyer's major final dissent, so it was very courteously written, it took issue with a number of things, actually with everything in the majority opinion. Firstly, and this is true of the McDonald and Heller cases as well, and perhaps a sort of victory of Justice Scalia in terms of method, they engaged very heavily on the history. Now, Justice Stevens in the Heller case back in 2008 and Justice Breyer in the Bruen case disputed the history, but they did go into it, and they made their own historical arguments about why there were regulations dating from medieval England through colonial era and forward through the frontier of the American West that would justify a regulation of this kind. And the majority, Justice Thomas, responded that, no, your examples aren't relevant, but mine are. And that was basically, who had the best history. But then Justice Breyer went a little further and said, I also disagree with your method. And he argued that we look at many constitutional rights, we balance that right against the public interest. We do that with speech, we do that with many things, and we should do that here too. We don't simply look to your conception of history and tradition. And he also argued that if the history is at best ambiguous or a mix, the tie goes to the current generation and its elected representatives to decide the proper way to address what everyone, including majority, agree is a serious problem of gun violence. And then there was a sort of interesting replay of this debate that came in the Dobbs decision, where the three-justice opinion that sounded very Kagan-esque argued that the majority was doing history one way to reach a result in Bruen, the gun case, and kind of doing it a different way to reach a result in Dobbs. And of course, we don't, not for us to say, well, up for you to say, not for me to say who's right on that one. So that's what happened with the gun case. It was very significant because it changed the way that lower courts must examine gun regulations going forward. It even called into question, interestingly enough, some of the provisions of the recent bipartisan legislation that President Biden signed. For example, you saw people, both Republicans and Democrats, wanting to emphasize like the mental state of the gun acquirer as being more important than the weapon, and red flag laws, someone who has a history of abuse or violence or instability or a domestic abuser, people like that would have a red flag on their record that make it difficult or impossible for them to acquire a gun. Well, Did they do that in Massachusetts Bay in 1696? I mean, we don't know. I mean, maybe they did, but there are some modern efforts to deal with this approach that some of which, like that, have some bipartisan support that may not be historically anticipated. And how would a court deal with that? That may be a question that we see going forward. But I'd be happy to hear what everyone else thinks.
So I'm sure it was gratifying for Justice Thomas to write the majority in this case, because he had been, sort of pounding the drum for the past decade plus that the court needed to take another Second Amendment case. He called it constitutional orphan in one of his dissents from denial of cert. And in another one, he tallied up how many First and Fourth Amendment cases the Supreme Court took in one term and compared it with, how many years it had been since the court had taken a single Second Amendment case. But I'd love to hear your thoughts. Is this the beginning of the end for the tiers of scrutiny?
You mean tears, not like crying tears of
Or
scrutiny.
should we
You
be
mean
crying
like
tears
levels
for the
scrutiny?
tiers
Yeah,
of scrutiny?
Exactly. You asking me? Or?
Sure.
As you're getting a sense, as Jess said, we have just lived through perhaps the most important Supreme Court term since maybe the one that decided Brown and the other one that decided the Pentagon Papers. I mean, it's sometimes when you focus on individual cases, it's hard to see just how historically important this last term was. And I would say it's important not just for the individual cases, but what they represent. And so what I would say about Jess's description of the Second Amendment case is that one thing that's remarkable is that you could say there was the Warren Court where Justice Breyer's opinion would have fit in nicely with a Warren Court opinion. It's pragmatic, some history, some structure. What's the effect, the consequences of decision? You can see, as Ranesh pointed out, and in this case, there's no longer a dialogue between that older style of interpreting the Constitution and what you might think of as this new sort of conservative revival on the court, which is all about history. And so it's almost as if the debate on the court is internal to the 6 conservative justices now. And the kind of arguments that Justice Breyer made, or the 3 justices in the dissent and the abortion case and Dobbs made, they don't have any purchase anymore. It's almost as if the majority doesn't even bother responding to a lot. There's like a lot of arguments that Breyer makes. They're really good ones. The majority doesn't even respond to them at all. And so that's a big change. You could see the Rehnquist Court now. I didn't think of it this way until now. That Rehnquist Court was this transition between the Warren Court and what we have today, and there was a struggle over that. And there were places like AEI where soon Justice Scalia and Judge Bork, they developed this school of originalism in response to the Warren Court. You could almost say like this term was the fruition of this style of jurisprudence that started here and Justice Scalia and Judge Bork developed. And you finally see now what it looks like when they agree there is an individual right, how they would protect it. And they protect it in a very expansive way, right? Basically, the court is saying, if you cannot restrict this right unless you can show us a historical example at the time of the writing of the amendment where the government was allowed to restrict this right. I mean, there's a very high barrier to breach. And it's going to, I think, starting to get applied in places like First Amendment free speech. You're seeing it in religion. You're going to see it, I think, in property. That in some ways is even more rights protective in a way than the previous courts once you would get agreement on something being a right.
Just a quick little point on this. Yeah. After Justice Barrett was confirmed, I was talking to one of then President-elect Biden's advisors, and as you know, then as the chairman of the Judiciary Committee, then Senator Biden led the effort to defeat the Bork nomination, and the advisor told me, well, we slowed them down for 40 years.
It's
true.
2 points. First, what strikes me about the way that the liberal dissenters approach gun issues and have from 2008 onward, and I'm including Justice Stephen's dissent in Heller, is that actually there is a kind of attempt to create a liberal originalism and go through the history of, and that's something that you really didn't see that much of. I mean, Blackmun gestures kind of ridiculously towards the history in Roe, but that was an era in which the liberals were much, much more interested in counting to 5 than doing any kind of historical inquiry. And so the whole ground of the debate has moved in an originalist direction. And then second, a kind of an extra legal point, but just for the political context, I do think the gun cases have this odd effect on the debate where we exaggerate their practical importance so far. If you think about the main policy issues that have been in contention in Congress about guns, none of them have been directly ruled on by the Supreme Court, and it's not 100% clear how the Supreme Court would rule on them. So expanded background checks, I don't think there's really much in any of the conservative decisions from the Supreme Court that would say, if the advocates of that got over the political hurdles and got it passed, that would now be in danger. And so I think we tend to think, people who are frustrated because they want more gun regulations than we have in this country, I think devote a little bit too much of their attention to the Supreme Court than actually makes sense. They haven't surmounted the political hurdles to get in front of the court in the first place.
I think we should move on to the Biden administration losing a lot this term. Which case do you want to start with, John?
They just lost tonight. You could add that in.
You'll tell us all about it, I'm sure. I actually have, I think, the most boring, but I think in the longer run, maybe the more interesting case, which is West Virginia versus EPA. So whenever you see West Virginia or EPA in the caption of a case, you should probably skip it and get to the other ones, because it's going to be boring. But I'd say this, I think this is, the last two cases in a way, as a scholar, I didn't see anything surprising in the opinions. They kind of turned out the way I thought they would. They used the arguments that have been developed, as I said, over decades, criticizing these different approaches, these different outcomes in past cases. I think West Virginia versus EPA is a break from what I think of almost as tying up the loose ends of the Rehnquist court and starting the Roberts court off in a new direction. Because if you're going to be a historian, say 30, 40 years from now, and you're going to look back at the Roberts court and say, what did as a whole mean, not just one case here, one case there, I think what they're going to say is that the Roberts court really tried to pull down the administrative state, that was its guiding mission that makes sense of all the other things it's doing. And it's been going, people in Washington, people who are interested in constitutional law have seen it, but I think now it's starting to pop its head up and become an important political issue in a way people had not really paid attention to it before. So one, what is the administrative state and how's the Roberts court trying to pull it down? So the administrative state is, I think, really the brainchild of Woodrow Wilson and was put into effect by FDR, and it describes the government as we know it today. And the idea was Congress and politicians should not make most of the difficult decisions facing policymakers. Instead, what you want to do is have the legislature grant most of the power to experts in the executive branch, but those experts would be insulated from political control by either the president or Congress. And most of you would probably be surprised to learn most of the federal laws that you and I interact with on a daily basis are really regulations issued by the administrative state rather than specific statutes passed by Congress. This is why I say it's a thing that's the Roberts Court, that's going to be the Roberts Court's thing, new thing, is that conservatives and liberals were both in favor of this basic design for a long time, including Justice Scalia and Judge Bork, were actually big supporters of different elements of this structure of government. So what has the Roberts Court's been doing? How have they attacked it? One, in a series of decisions, the Roberts Court has made more and more of the officers of the executive branch who run this state accountable to presidential removal for any reason at all. And that's been going on now for 30 years, but the Roberts Court has actually been striking down the design of agencies, the most important one being the Consumer Finance Protection Bureau. West Virginia versus EPA is pulling at the second part of this design, which is granting power from Congress to the agencies. So West Virginia EPA, I really hope none of you have the painful task of reading the regulations at issue here, or even the statute. But the easy way to describe it is the EPA, without dispute, has the power to decide how power plants work, how much they can pollute, what equipment they have to use, and so on. The Obama and then Biden administrations tried to say, we also have the power, when we give out permits for plants, to consider the effect on the whole system, the whole network of electricity production in the country, and the cause of reducing emissions to combat global warming. So what they basically try to say is, we're going to take the power to regulate individual plants and make it a power to regulate the network as a whole. In simplified terms, what happened? The court said, no, we're not going to allow you to pass a regulation like that because Congress never would have given you that power in the first place. The problem for the court is that Congress's statute basically says the EPA can make the air clean in the public interest using means that is up to the agency. And the court has in the past allowed the EPA to run with relatively free hand to issue these regulations. So the court created this new doctrine called the Major Questions Doctrine, which this is the first full major Supreme Court opinion this has appeared in, except for some of the Obamacare cases where no one was sure whether it was just a one-off or a permanent feature of how the court is now going to monitor what the agencies do. And so the court said, if the agencies tried to regulate something of important social or economic significance, and you're doing it for the first time, and Congress has never allowed you to do this before and and hopefully for the court's view, has defeated efforts to do it through legislation, we're not going to allow agencies to claim a new authority under these existing laws to regulate in this new area. So if you think about what the Biden administration, because Elizabeth said, talk about the cases the Biden administration has lost. This is about all the cases they're going to be losing for the next 3 years, because there's going to be a lot of them under this test. Any kind of effort to do a new thing in regulation is going to have a significant obstacle now because of the West Virginia versus EPA case. I'll say the other thing is, and I think this is how, and I'll end here, how it has a common theme with, one last thing. It was not as radical as conservatives wanted. Conservatives were calling on the court to revive something called the non-delegation doctrine, which would have placed even tighter controls on what the Congress and the agencies could do. Although I think this major questions doctrine is kind of like a halfway house on the way to the non-delegation doctrine. But one thing I think that's in common with the other cases we've talked about, and this is very different, I think, than the Bork and Scalia approach to constitutional laws, you don't see a lot of deference anymore by this court to the other branches. They are extremely confident in their ability to say, no, you can't do this. There's not a lot of what used to be called judicial restraint to the judgment of the political branches. And you see it no more and more clearly than here, where the court is going to say, we are not deferring to agency judgments. We are not deferring to Congress's giving agencies power to regulate all the air and the water. Instead, the court's saying, we are confident that we can tell whether what you have done is the proper thing under those laws passed by Congress. So I think that's another thing that it's the end of the Rehnquist period, the end of the Warren Court, Rehnquist Court fights. This is a new direction because conservatives and liberals, both for a long time, I'd say for 30 years, used to agree that the courts should not second guess the agencies and let the Congress and the agencies devise things for themselves on how they want the administrative state to run. So you're going to see a lot of that regulations challenged. I think there's a lot of regulations that the Biden administration is trying to push forward that are in big trouble, like the ESG regulations coming out of the Securities and Exchange Commission, a lot more of the EPA regulations. Any effort to deal with global warming is probably not going to fly in the courts now. Last thing I'll say is, and this is going to be the Supreme Court that's going to be doing it, because a lot of the lower courts have not really implemented this kind of aggressive review of agency action the way that the Supreme Court is calling for.
Except maybe the Fifth Circuit.
Yeah, except Texas, which is a separate problem for constitutional governance.
So I want to get to Coach Kennedy's case and Justice Breyer's legacy, but I also want to leave time for some questions. So do you think we have time to do both of those quickly?
We don't get a chance to refute John first?
Refute away.
Refute.
You have 30 seconds.
I would just say...
Agree quickly.
Yeah, agreeing is even quicker. I would say first, the non-delegation doctrine is a really interesting case because I think we think of it as dead or moribund, but it's actually had this kind of spectral presence in the law for a long time so the courts will construe a law to not give all this discretion to agencies in order to avoid a constitutional problem. What's the constitutional problem being avoided? The problem is that at some point, the legislature can't give away all of its authority to some unelected agency. So in a way, it's just a question of a kind of of a ghost that's kind of slowly being reanimated. And liberals can think of it as a Voldemort analogy if they want to. I give that one away for free. And I would just say there is a real danger, a more real danger than I think some conservatives appreciate, of a political backlash if the court moves too far, too fast, too rashly against the administrative state. Dobbs generated this huge popular backlash, but there's nothing that Dobbs denies the public that the public can't get easily some other way. If the public really wants a national abortion rights regime, that can be passed by Congress and signed by a president, and the court has not yet indicated anyway that it would do anything about that. But if we get into a position where the public and the elected branches do want something and there's no way to get it without going against the court, that's a different situation. That's the kind of situation that the court faced in the 1930s, and I think that it's not an accident that is the kind of situation which generates a real political backlash that actually threatens the power of the court.
I had a question. I wonder if the major questions doctrine is in tension with the history and tradition approach that the court articulated in the other cases, because in the dissent, it was a single justice dissent in the EPA case by Justice Kagan, and she actually threw back at the conservatives a line that they like to throw at her when she once said that we're all textualists now, and she said, I spoke too soon, because there's nothing in the text of the Constitution that talks about this doctrine. It's completely invented by the court to hamstring agencies. The founding era saw Congress make huge delegations to the chief executive, to President Washington. Why are we doing this now? It's only because the court doesn't like what they're doing. And that was her argument, that this is just an invented doctrine, no constitutional basis. Congress, you look at the text, as John said, Congress seemed to appreciate that whatever it is they are, they're not good at science and math, so they delegated figuring those things out to the nerds who work at the EPA. And you take care of it, because we're not going to sit here and deal with these formulas and in our test tubes and figure out how pollution works. So why wouldn't the Congress do that? How could a Congress possibly become experts in air pollution to legislate on the level of specificity that the court seems to be demanding? So I just ask, is there a tension, or does it all make sense on some higher level?
One, I don't like the major questions doctrine myself because it doesn't have any predictability to it. It does have this sort of made up on the fly favor to it, which is why it's Chief Justice Roberts writing it. It was like multiple circumstances and balancing, and you'll never figure out because I'm smarter than you, and here's the doctrine, right? You cannot tell actually which laws it will apply to in the future because the test is so vague.
It's the obscenity test.
Yeah.
The super duper major important laws.
Exactly. But I think Jess has a good point, which is, but this goes into how the Roberts Court will be different, is it's interesting now, in order to justify it or not, ultimately will depend on historical analysis. And I think you're right, the dissent is saying, where's the history? And the majority isn't as adept, because again, I think it's Chief Justice Roberts here who's not as much on the history bus as the rest are. But if you had Justice Thomas or Justice Gorsuch's concurrence here, which is worth reading, his concurrence is more a reach to the founders would never, and I think this is motivating some of them, would never have thought the administrative state could exist in their original three-part design for the separation of powers. And I think that's where we're going on a slow basis, is eventually the court is going to say the administrative state has to fold into the executive branch somehow like a normal department and can't exist as this fourth branch, but they're not ready to do it yet. I think it's funny, I think to Renesh's point, they do know the lessons of the 1930s when FDR smacked them down for doing exactly this. So I think they're going to take like 10 years to do this rather than trying to do it all in 2 years because of the political pushback.
And of course, they have to wait for the cases to come to them.
Yeah.
Coach Kennedy, do you want to mention briefly?
So yes, the first recorded instance of a good Joe Kennedy in American history. A football coach. This is a church-state case where, as is often the case in these church-state cases, it's a very fact-intensive inquiry. The probably one of the high points of that fact intensivity, or maybe the low points, depending on how you look at it, being that time. I think it was in '05. You had two Ten Commandments display cases, and the court said one of them's okay and the other one isn't. And, based on these, multi-factor analysis, where we decided, well, one of them's really coercive on reasonable observers, and the other one isn't. In this case, one of the oddities is that the majority and the dissent, it's like they're looking at completely different fact patterns in the same case. So Justice Sotomayor, in her dissent, actually reproduces pictures of this coach's post-game prayers where he's surrounded by students. And some of the commentary on this case has suggested that the majority was being sort of dishonest or selective in its presentation of the facts, and suggesting that this coach is just sort of praying by himself and there's nothing coercive about it. But the fact is, it was the cases where he was praying by himself that he was fired for. So there was a shift in the fact pattern in the middle of the longer saga of Kennedy and these post-football game prayers. And for that reason, it is certainly possible. There's a lot of language in the case that suggests the court is backing away, has been backing away for a long time from strict separationism and from the kinds of tests it had outlined in Lemon versus Kurtzman about excessive entanglement between church and state, about the appearance of endorsement, and so on and so forth. But I do wonder whether some of the apparent doctrinal change is kind of ephemeral, and fundamentally things do depend on a kind of fine-grained factual determination. That said, you can't deny looking at the overall arc of establishment and free exercise clause cases, and there was another big one that we might get to later, and not say there's been an overall shift towards being more sympathetic to the claims of religious actors and less to the kind of the person who sees the crutch on municipal property and is afraid that we're going to Handmaid's Tale territory.
Any comments?
Well, I think it might be a good way to tie this case to Justice Breyer's legacy, actually, because although he did not write the principal dissent here, he did write the controlling opinions in the Ten Commandment cases that you mentioned, Ramesh, the ones involving one from Texas and one from Kentucky, and he reached contrary conclusions that one Ten Commandments display was constitutional and one was not. And why was that? And in that case, back in 2005, he found that the effort by the Kentucky courthouse to install Ten Commandments displays in the courthouse was really a provocative effort by that court, by the officials in that county, to try to send a message like, this is a religious, Christian, Judeo-Christian, whatever, community, and you better just take it. While the monolith in the Texas case had been sitting in the park outside the state capitol for 50 years, no one had even noticed it until this lawsuit had begun. And to him, the same thing was accomplished by trying to remove the monument. It was a provocative act to disturb the religious comity of the state. So for him, it was entirely consistent because he looked at the religion clauses of the Constitution and had what I have always had trouble pronouncing it, a purposivist view. He looked at what he viewed as the purpose of the religion clauses. And what he said the purpose was to allow a pluralistic society to coexist, to take religion out of the mixture of things that people fight and argue about by getting the government out of religion and getting religion out of government. So all the religious wars that preceded the founding of the United States would have a lesser chance of arising here. So that is how he saw it. And under that approach, which you could say he followed in other cases as well, he looked at what he thought the grand design of a constitutional provision or a statute was and saw his role and the court's role as trying to give it its most efficient effect. And he used to argue about that with Justice Scalia, and although he outlived Scalia pretty much won the argument, at least based on historical facts on the Supreme Court, maybe not on the faculty at Berkeley, but on the in the chambers
I
of the
know,
Supreme
but
Court.
Breyer's too conservative for the
Right,
faculty
yes.
of Berkeley.
Right, didn't Metzenbaum oppose him, I think? But the formalistic approach that doesn't really look at how does this work, is this being implemented in a way that accomplishes what we think the purpose was, that has fallen out of favor and is now the predominant approach that Scalia championed, obviously, and that his former clerk and his admirers on the court now pursue, is we're not really looking at that so much. We're looking at what the formal right is. And the question for us is, how do we identify the contours of that formal right? And in the case of the Coach Kennedy case, they concluded that there was no prohibition on this kind of religious expression in the public schools that didn't exist in 1791, and therefore, the idea that this reflected an establishment of a religion was preposterous, and that, of course, was the rationale that the school implemented. So Breyer's overall approach, he was a big believer in the administrative state. He did believe in the idea of enlightened experts contributing their knowledge and judgment to society. He did believe that people of goodwill working together could come up with better solutions, and he tried to accomplish that on the Supreme Court as well. And I think that because he was so genuine in this belief, whether people agreed or disagreed with him, I think he was very well liked because of it. I think everyone thought this is a real good egg. He doesn't have a secret agenda. It's not like this is a cover story for something else. This is what he really is about, and this is what he sincerely is trying to do. And sometimes, even people who disagreed with him found ways to accommodate with him. From what I've heard, for example, the Chief Justice voted in opposition to Breyer many times this year. He felt very personally close to him, right, and is going to miss him. And he had a way of approaching things that I think he sought to explain them to a broader public. It wasn't always. I would say that he didn't really have, you might say, the common touch. Okay, he was not the kind of person who could popularize ideas the way that Scalia could, or even that Sotomayor, who's been on Sesame Street, can do. He didn't have that kind of talent, but he certainly had that ambition, and he tried, and he made himself available to do it. A few years ago, I co-taught a course on the Supreme Court at the UC Center here, and when there were Supreme Court events going on, I would tell the students they could go to them. So remember, Breyer's talking at something, and so I told the students, and some of them went to hear him, and afterwards, they went up to him afterwards, and they ended up in a half-hour conversation, these two sophomores from like UC Irvine, just sitting there with this justice talking for half an hour, and they came back, and they couldn't believe it, but I could believe it, because that is how he was. So there's a certain kind of humanity and humility on one hand, and a certain belief in the benefits of government, the abilities of government, confidence in the institutions of society that he reflected. Maybe that is a legacy of the 50s, 60s when he grew up, and that is now gone. So I guess we'll just have to read his next fascinating book to see what he's thinking about. So I don't know if that is a good appreciation, but you obviously were a clerk when he was there. I'm sure you've met him and talked to him many times. Ramesh, what do you think?
It's unfortunate in a way that this term was so important that we're not seeing the reflections on Justice Breyer that you normally would, and his influence on jurisprudence and the court. But on the other hand, when I think about him, I think about him much of the way I thought about Justice Ginsburg. Maybe I'm wrong in the sense, and I don't mean to be mean about this, but I think they were much more important before they were on the Supreme Court than when they got on the Supreme Court. And because one is they were always in the dissent on basically a conservative court. So Justice Ginsburg had one great majority opinion, the VMI case. I cannot actually think of a great Justice Breyer majority opinion for the court, the kind like the ones we're talking about today. But that's because he was just in dissent.
He wrote the recess appointment decision.
Yeah, like I said, no great opinion. He wrote opinions. Like,
I thought it was great.
Yeah, so he's like, it's a week, not 3 days or something. But there was no, so a lot of his opinions, the great opinions that he wrote, are dissents, as are Justice Ginsburg's. Because they were usually playing defense, trying to slow, like usually with that story he told, just slowing down this 50-year, maybe, conservative revolution in the courts. And the second thing is that we should not understate how important Justice Breyer was before he was on the court. Just like Justice Ginsburg stood for the rise of women's equality, and her achievements are on a par with Thurgood Marshall's with race when it comes to gender.
Who also had, in some ways, a bigger career pre-Supreme
Before he
Court.
was on the court, yeah. Justice Breyer, it's going to pass from history, but Justice Breyer was a liberal leader, a democratic leader in deregulation. I mean, if Chris DeMuth, one of the great leaders of AEI, was the conservative champion of deregulation, his partner in crime would be Steve Breyer. I mean, he was a significant figure in the 70s saying that government should lift its hands off the economy. And to stand for what Jess is talking about, a pragmatic view of what the law does with an attention to the consequences it has on the lives of everyday people. And you can get a sense, this court, that's not what they're interested. They're not a pragmatic court. They're not trying to measure the costs and balances, benefits of everything. They're more interested in sort of clear, bright line principle rather than maybe getting the policy right. But I agree with just a story. So I clerked on Justice Breyer's first year on the court. And so there's a tradition that each of the justices over the year will have lunch with the clerks from the other justices' chambers. And so some of them are quite intimidating. I mean, some of the justices at the time I clerked had been soldiers in World War II. Right? These are not like normal people to you. They're like, demigods. You have a big difference between you and them. Some of them were very formal. For example, some of them would send memos to their clerks about discussion cases. The younger justices are not like that at all. I think they are much more, let's talk in person. Justice Breyer was remarkable in that he didn't treat clerks like you were some subordinate in the court. He would love to argue and talk with clerks as much as he would want to talk with judges and other justices. So I think Jess is very much right about that he was sort of open and accessible to everybody, very interested in ideas more than the people that were espousing the ideas. He was just more interested in the ideas and figuring out. I think that's why he liked debating, went on the debate circuit with Justice Scalia, because Justice Scalia had that about him too. They just were so in love with the arguing about ideas rather than the name or position of the people they were arguing.
Still, he was more like the Washington Generals to Scalia's Globetrotters, but still,
Well, Justice Holmes lost a lot of cases too.
The final thought is that, and Breyer, as John said, he was not a Warren Court liberal in a lot of ways, even though he clerked for Justice Goldberg on the Warren Court and maybe contributed to his famous concurrence in Griswold. But that is also part of the reason that he was more harder on criminal defendants than many of the other liberals, sometimes more so than Scalia or Gorsuch would be, who are more formalistic in their approach to the Bill of Rights. Breyer also believed in the Sentencing Commission. He believed in probation officers. He believed in the criminal justice system's ability to evaluate the proper treatment of criminal defendants, had more confidence in that than either the liberals who didn't really trust it or some of the formalistic conservatives who would believe that it says confrontation clause, it means you get to confront the witness in person, not through some other means. So again, part of his approach, I guess, overall.
So Justice Breyer's, one question that I've always had in my mind about Justice Breyer's, he was the junior member of the Supreme Court for a long time.
Probably
for
the
11
longest
years.
of any justice ever.
Second longest. I forget who the
12 years,
who
I think.
the first one was. And one wonder, obviously he came to the court as an adult. He had his own style and personality and views. But one wonders whether that experience did also shape the kind of justice he became, the degree of assertiveness. The other thing I would just say is that he didn't just lose the fight for the Supreme Court to Scalia. It's also interesting, there's this whole body of thought. There are a bunch of conservative legal thinkers, judges, law professors, and so forth, who think of themselves as being, to a very large extent, heirs to Scalia and continuing largely this whole body of thought. And I don't think Breyer was nearly as successful among his fellow liberals in that. I don't know that active liberty has been nearly as influential on the left as Scalia's work on the right has been, that there's no sort of Breyerian school of jurisprudence that is a big part of his legacy, even though people may admire him personally and may like some of his decisions or some of his dissents. that in a way, the Scalia versus Breyer contest, they're playing a completely different game.
Well, unfortunately, we've gone over time, so I think we're going to have to cut it off here. But for those who are in person, we can continue the conversation over perhaps a cocktail. But on behalf of Pacific Legal Foundation, National Review Institute, and American Enterprise Institute, I want to thank all of you for coming. I want to thank our panelists, and we hope to see you again soon.